we are starting our International Day. First of all, I will introduce myself. My name is Jane Raspopova. I am patent attorney, IP lawyer who deals with trademarks and authors' rights. I work for Niva Patent's patent law company, which is the co-organizer of our international forum, which is conducted for the third time actually this year. And the forum is called Intellectual Property for Future. So we welcome everyone on our 7th day of the forum. Yeah, the forum is planned and will be conducted for 8 days. So today is our 7th day of the forum. All the events today will be in English only with no translation into Russian. So it's kind of a challenge for people to practice English, and that is actually one of the aims of our International Day, so that we can share our best practices and communicate, discuss and talk with partners all over the world. So we are really delighted to welcome our partners from India. I will introduce them a bit later, but just a couple of words about our forum. So it's international communication platform for demonstration and popularization the best practices in the sphere of intellectual property. And we actually discuss innovative development of our industry, and we are delighted to share best practices, business practices, educational, research, scientific, creative, and cultural activities. And we believe that such kind of events are really important to improve the knowledge of IP rights for people all over the world. Whereas nowadays, we're not talking about some outside situation, but we are talking about law, and we are talking about how important it is to have international communication and international partnership. That's really important because our principles of intellectual property, principles of law are forever, and it's not discussable for sure. So today, the first event will be conducted, will be introduced by our partners from India, Miss Vibha Bandhu. I'm sorry for my pronunciation, please correct me later.
Ma'am, it's perfectly correct.
Thank you. And Mr. Prabhpreet Singh. I'm very sorry again. I'm very bad at pronunciation. Assistant professors from School of Law, Manipal University, Jaipur. Please introduce yourselves once again so that we can address you correctly. The topic of presentation is International Exhaustion of Patent or IP Rights and Parallel Imports, a Comparative Study. Why it is so important nowadays? Because people from Russia know that recently in March we got some new regulation. It's not a part of civil code yet, but I think it should be corrected pretty soon. And it's about parallel import, because before in Russia we had some regional regime of exhaustion of IP rights, and now we have international regime. So such comparative studies are extremely important for us to understand how to develop further and what will happen in like future time, maybe 6 months, how we will just live with that new regime. So I'm switching off my sound. Sorry for such a long introduction. Please feel free to ask questions in chat. We will check it. Also, some organizational issues. If something goes wrong with internet, please reconnect using the same link. We will just use the same. If, I don't know, some internet lapse or something. And please don't switch on your sound. I think that we can answer on all the questions after the presentation is over, and that's pretty standard situation. Okay, so Thank you once again. And please introduce yourself.
Thank you so much, ma'am. First of all, a very good morning to all of you, to all the one who are present here. So I feel very glad to be a part of this particular event today with respect to intellectual property rights, which is, again, as ma'am suggested, that it is very relevant considering the present situations. And at the same time, it becomes very important to understand the laws, the regime, the legal regime which is present in the country, so that, you know, it becomes basically imperative how to bring a proper balance in the countries where, with respect the issues with respect to the jurisdiction, and how it will be impacted, you know, how it will lead to an international impact overall. If we talk about national exhaustion, if we talk about the concept of international exhaustion and regional exhaustion. So a law of one country has a direct impact on other countries' laws as well. So that is why it becomes important to understand this particular context in the present situation. So I, Ms. Vibha Bandhu, I'm an assistant professor of School of Law, Manipal University. I am presenting this particular topic with my co-colleague, Mr. Prabhpreet Singh. Again, he's an assistant professor, Manipal University. So without much further ado, I would like to start the topic. Ma'am, can we start with the topic now? All right. Thank you so much, ma'am. So since our topic relates to international exhaustion of patent right and parallel import, so in this particular topic, first of all, we are going to discuss the doctrine of exhaustion, what exactly doctrine of exhaustion means, and then what is the concept of parallel import, and whether, if in India, do we have any law, if any, there is any legal regime which talks about this concept of parallel import, and if it does, then what rule of exhaustion does it include? So we are going to start with now. Ma'am, can you please turn to slide two?
Just to make sure, do you see the second slide? Is it okay?
No, ma'am, not yet.
Okay, so just a second. I will stop my demonstration and do it once again, because up to me, I see the changing slides and I understood that something goes wrong. Just a second. Okay, do you see the presentation now?
Yes, ma'am, the first slide.
Do you see the introduction slide number 2? No?
No, ma'am, not yet.
Okay, just a second.
Ma'am, should I try to share the screen from my side?
If you can try to, yes, it's just some technical issues. We are sorry for that, but it's not a problem.
Perfectly fine, ma'am. I'll just try it from my side.
If you can put a bit higher, because right now we see just a part of the slide. Better, yes. At least we can see the content of the slides.
Is it fine now, ma'am?
Usually we need to push F5 button to make the presentation be on the full screen.
Oh, okay, just give me a second.
Yeah, perfect. I can see that. Yeah, it goes. So once again, if you can.
Ma'am, are the contents visible now? Because even after pressing F5, like this is what.
Once again, yes, F5, once again, so that the show is on.
Are we audible now?
We can see the slide, but it's not on the full screen for just right now. But it's also okay, whereas we can see the content.
Like we have to make control. Okay, so ma'am, shall we continue with this?
Yes, we now see the slide overview. which is number 2.
Sorry, ma'am. Okay, yeah. So second slide, yeah. So we'll be discussing about all these doctrines of exhaustion, parallel import legal regime in India, and whether it is complied with the TRIPS agreement. So now moving forward. So first of all, talking about patent, again, patent is a concept which we define as a bundle of exclusive rights which are granted to an inventor whose invention basically satisfied certain sorts of conditions. That is, it should be novel, it should be completely a new idea, it should be non-obviousness, and there should be some utility. So if all these prerequisites are fulfilled, then we consider that a patent can be granted to the IP holder. So again, when a person invents something with these particular rights, then there are some rights protected by the law which are exclusively belongs to IP holder. So for instance, once a person has created a product, invented something, and once he has obtained a patent in a particular country, in that case, he is granted certain rights which are exclusive with respect to right to make that good, right to use, right to sell, and right to import those patented goods into such country. So the patentee holder has certain exclusive rights whereby he can prevent the third parties from producing such goods. Again, these rights are not limited. These rights are not absolute. Okay, so again, every right has certain limitations. Similarly, when we talk about patented goods, again, there are certain limitations. And when we are talking about this concept of exhaustion, we can say that exhaustion is one of the limitations on the rights of the patentee holder. So here comes the doctrine of exhaustion. So now, what exactly is doctrine of exhaustion? So doctrine of exhaustion, which is also termed as doctrine of first sale. Now, this implies the idea that once the patentee releases the patented product, once he releases that patented product into the market, once he sells that product, or if he authorizes that product to be sold, after that first sale, he exhausts all his legal rights with respect to that particular product. So this is basically doctrine of exhaustion or doctrine of first sale, is that if the patent holder has authorized the sale of the product, or he has himself sold the product, then he has exhausted his right to further control that particular product. So now, what is the rationale behind this theory of exhaustion and doctrine of first sale is that the patentee, since after the first sale he has already been rewarded, so he should not be allowed to profit again and again on the same particular product. And again, to promote free trade and to prevent monopolistic activities, this doctrine of exhaustion has been introduced. Moving forward, now when we talk about doctrine of exhaustion, so doctrine of exhaustion, every country has different concepts with respect to exhaustion. Now, what we follow, it depends on that particular law. So basically, there are three kinds of exhaustion under this concept of a doctrine of exhaustion. So basically, let's take one particular example. So let's say if IPR holder, he holds a patent with respect to a particular product in two countries, in two jurisdictions. Let's say there is country A and then there is country B. So now, if I have obtained the patent in both the jurisdictions A and jurisdiction B, now what will happen if I put those goods in market for sale in country A? I have not yet initiated the sale in country B. I have only opened the goods in market for sale in country A. Now the question comes is whether my rights will also be exhausted in the country B. So the answer to these particular questions depends about what kind of exhaustion a particular country follow. So if we talk about the kinds of exhaustion, first of all, if again, in that particular, the hypothetical example, let's say if the jurisdiction of country B follows the principle of national exhaustion, then in that case, the sale of patented product in country A will have no effect on B. That means since I have already sold the product in country A, but I have not done anything in country B, so it will remain unaffected. That means the IPR owner will not be able to control the importation of goods in that particular state only, and his right will not be exhausted with respect to country B, because in country B, he has not yet initiated the sale. So only in the if it is national exhaustion principle, then country B will remain unaffected with the sale of goods in country A. So, but in case of national exhaustion, IP owner right is exhausted within his domestic jurisdiction, and buyer in that jurisdiction, he can engage in subsequent sale. So in that particular country A, he can, so if the patent holder has sold a particular product to person B, then we can sell in that particular country to other sellers as well. That right will be exhausted, but the countries B will remain unaffected from this particular sale. Now, second situation, international exhaustion. So again, if we, in this particular situation, if we take another example where if the country B jurisdiction follows the regime of international exhaustion. So in that case, the sale of patented product in any jurisdiction of the world will exhaust his right in any part of the world. So if in jurisdiction A, if I have sold the patented product to any person, now that will exhaust my rights in any other countries of the world where I have obtained the patent. This is what the principle of international exhaustion implies. So now any importer from any country A is free to import that product in his country, and he can engage in this gray market to enjoy the benefit of price differences without altering with the quality of the product. So in international exhaustion, if you sell in one country, you will exhaust all your rights with pertaining to other country as well. And the third kind of exhaustion is regional exhaustion. That is, if a country follows the regional exhaustion regime. So if the patented products are put in the market with his consent in that particular regional block, then it will also exhaust his right to sell in other regions. So if we talk about European Union, it's a very good example of regional exhaustion. And if a sale of product within that particular union exhaust the right in other parts of the union as well. So these were the different kinds of exhaustion, which are which again depends on the countries that what kind of exhaustion they are allowing. So here in the context of India, when we are talking about Indian patent law regime, first of all, Indian patent law regime dates back to 1970. So if we talk about the concept of parallel import, so again, before talking about which exhaustion India follows, let's talk about the concept of parallel import. So initially, since the act was enacted in the year 1970, initially there was no provision which discussed about the concept of exhaustion. But in the year 2002, there was an amendment which provided a provision with respect to parallel imports, which provides that. So the relevant provision is section 107A clause B, which provides that importation of patented product by any person from a person who is duly authorized by the patentee to sell or distribute the product shall not be considered as an infringement of patent right. This was the provision which was initially introduced by way of 2002 amendment, but the expressions, the terms used in these provision was considered very narrow, and the scope was very limited since it includes a person who is duly authorized by the patentee. So that means every other importer has to consider that that he has taken the goods from the patentee only, or who is duly authorized by patentee to sell or distribute the product. So in that case, that was considered very restrictive approach to this particular concept. However, in the year 2005, an amendment was inserted in this particular provision, and now the amended version reads as Section 107A clause B, importation of patented products by any person from a person who is duly authorized under the law. So initially it was as we can see from the presentation, initially it was from a person who is duly authorized by the patentee to sell, but now the changed concept is importation of patented product by any person from a person who is duly authorized under the law to produce and sell or distribute the product will not constitute infringement of patent. So with respect to parallel import, this is the relevant provision, that is section 107AB, which has been inserted by after 2005. Now, again, if we talk about the this particular provision, or if we talk about the statement of object and reasons, there is no such express provision which talks, there is no such explicit mention of these two terms, that is parallel import and exhaustion. They have not been used anywhere in the act, but it has been inferred from the parliamentary debates or different conferences that this section 107A clause B aims at permitting parallel imports, and it also endorses the principle of international exhaustion. So after reading this particular definition, we can say that yes, in India, we do have the law related with respect to parallel import, that is section 107A clause B. Secondly, if we talk about the determination of exhaustion, that is which kind of exhaustion we follow. So in that case, India follows a principle of international exhaustion. Now, the another thing is whether there is TRIPS compliance with respect to the Indian law. So now when we talk about TRIPS basically provides very much flexibility with respect to this exhaustion principle that the country wants to follow. So it gives flexibility to the member states to determine that what kind of exhaustion a country wants to exercise. And the relevant provision is Article 28 of TRIPS, which provides that every patentee shall have the exclusive right to make, use, offer for sale, sell or import the patented product or process in question. But if we refer to footnote 6 of Article 28, it adds a small caveat to the exclusive right to import. Yes, so this footnote 6 adds a small caveat to the exclusive right to import by clarifying that this right, that is the right of importation, like all other rights conferred under this agreement in respect of the use, sale, importation or other distribution of goods, is subject to the provisions of Article 6. So now for that we have to refer to Article 6 of TRIPS agreement. So Article 6 in turn states that nothing in this agreement shall be used to address the issue of the exhaustion of IP rights. That means whatever is mentioned in this agreement, it shall not be used to address the issue. Even if there is a dispute, it will not be raised as an issue in WTO. So that is what Article 6 states. And by reading this provision, it becomes very clear that the objective of the TRIPS is to again promote parallel import and to give the countries a free hand in determining what kind of exhaustion they would like to follow. Similarly, same is made clear by in the Doha Declaration, Article 5 clause D, which provides that the effect of the provisions in the TRIPS agreement that are relevant to the exhaustion of IP rights is to leave each member free to establish its own regime for such exhaustion without challenge. So these were the relevant provisions which dealt with the concept of parallel import and the doctrine of exhaustion rights, and with respect to India. So in India, we can say that yes, we do have parallel import. Secondly, it is the international exhaustion that we are following currently. Now, rest of the issues in this particular topic will be dealt by my co-colleague Prabhpreet Singh. Thank you so much. Ma'am, are we audible?
Sorry, once again.
Ma'am, are we audible?
Yes, we can hear you. Yes, it's okay.
All right. Okay, so ma'am, Prabhpreet will be presenting the next issues.
Sure. Also, I need to say that our video is recorded today. So after the forum is over, we will ask your permission if you can allow us to download your presentation into open domain. Yes, so that people, I really do thank you very much for such a detailed presentation. Of course, it just perfect lecture on the principle of exhaustion of rights and detailed research on each point of TRIPS and your laws. So thank you very much. Yes, I'm switching off my sound right now again, sorry.
Thank you, ma'am. So when we talk about this term of exhaustion and how it evolved through different case laws in different countries. So when we talk about this principle of exhaustion, there's another principle which has emerged during this time, and that principle is principle of implied license. Now, when the exhaustion takes place, when a patentee who has innovated a product and the patentee sells that product in the market, the first sale, which my already colleague has talked about. So if first sale happens, that means any other person now can use that product, and that person can also sell to different other buyers. And now this patentee has no right regarding regulating the sale of that product because the patentee has already sold that product first. Now, what happens according to the doctrine of implied license, in the exhaustion, we have seen patentee has no control. But in the implied license, the patentee can put some terms and conditions in the contract where the patentee can restrict the buyer. Now, when they are restricting the buyer, this is against the principles of free trade and other policies, TRIPS agreement, but this is a kind of doctrine which is followed in some countries like Japan, the doctrine of implied license, where the patentee can restrict the buyer on some certain terms and conditions. So in exhaustion, there is no control of the patentee, but in implied license, a patentee has a control according to the contract which the patentee does with the buyer. Now, how these doctrines have emerged and how they have evolved. So first in Germany, the Supreme Court of Germany decided in the case of Guajacol in 1902 that if a patentee has marked his product under the protection of a right that excludes other, he has enjoyed the benefit that a patent right confers on him and thereby consumed his rights. And that's why this principle of exhaustion came. And this genesis of principle of exhaustion was adopted in common law in 19th century, the first sale doctrine, which was referred by the Supreme Court decision of United States in Adams versus Burke. And this doctrine of first sale was further evolved as implied license by the Privy Council in United Kingdom in Bells versus Wilmot case. And when we talk about this, the system in India, we compare with some countries like we have exhaustion. Countries like Japan have principles of implied license. Now, the problem in Japan is that they do not have a specific regulation which talks or which may define whether they are following exhaustion or implied license. So in Japan, it has evolved through case laws and through Article 4 of Paris Convention, to which Japan is a party. So the principle of national exhaustion was followed in July 1, 1997, when this was laid down by the Supreme Court of Japan in BBS aluminum wheel case, which laid down that the import of patentee goods into the territory of Japan will not result into infringement of patent rights unless the patentee, now this is important here to note, unless the patentee has explicitly excluded such import into the territory of Japan by way of an agreement in writing. That means now they are curtailing from exhaustion to implied license, where still the patentee has some control on the patent which is being sold in the market. So this is one of the ambiguity which is faced in Japan and which requires some amendment. Like in India, we have the doctrine of international exhaustion. So if a person who is living in India and he has developed some innovation or a product and it is patented, and then that person sells that product in Russia. So if that person is selling the product in Russia, now the right of that patentee person is exhausted. Now he has no control on that product. So anyone in the world can use that product, can sell it, can produce it, and can do whatever they want. But according to, if we say recent examples, like in Russia, what has happened right now, because this principle of exhaustion applies on IPR. So it is dealing with patents, it is dealing with copyright, it is dealing with trademarks. Now, the conflict between different countries and Russia happened, and according to which the Russia have evolved its jurisprudence on the trademark. So what they are now doing, they are telling the retailers, because there's a conflict, most of the countries had put sanctions. Now what they are saying, the retailers from Russia can go to another country, they can buy that product, and now they can import that product in Russia. So they don't have to take permission from that importer. Now what happened in 2009 in Russia, there was a landmark case, the Porsche. Now in this case, Porsche case, a person imported the Porsche car from different country into Russia, and now that person who imported that car, that person or the company has to take consent from the Porsche regarding the use of that trademark of Porsche, but they did not do that. And now the problem was, because this is a good, and the authorities confiscated that good, the Porsche car. Now, can they destroy the car which has not followed the proper channel or the law? So what the court said, arbitration, the matter went into the arbitration, and the court said that the custom authorities cannot destroy that product. What they can do is, the company whose trademark is there, that company can go for obtaining civil remedies. They can ask for compensation, but they cannot destroy that product. Now they are following the regional, we can say regional or national, this exhaustion. And also Russia is a party of Eurasian Union. And this Eurasian Union, there are different countries in this Eurasian Union, which includes Kazakhstan, Armenia, Russia. And when it comes to the IPR rights, they follow the principle of regional exhaustion. So if a person in Russia imports or sells his product once, then that product can be sold in this whole Eurasian Union. That means they can sell the products in Armenia, they can sell the products in Kazakhstan, all the countries which are part to this Eurasian Union. So this is how this exhaustion principle is followed. And when we talk about the ambiguities which are there in countries, like some countries which follow the doctrine of implied license, because this implied license still gives the right to control that product to the patentee. So this principle goes against the principles on which we are following the free trade and the TRIPS agreement and other agreements relating to trade. So some amendments are required to be done in some countries. And moreover, it is, in conclusion, we can conclude that because there are different ways of exhaustion, like we have international exhaustion, national exhaustion, and regional exhaustion. So a demand has been made, why not follow one principle? Why different principle of exhaustion? So most of the countries are moving towards international exhaustion. We have seen this in pandemic, some countries waiving these agreements so that products can be sold and these products can be used for public welfare. So now countries are demanding towards more international exhaustion rather than national or regional, so that we can have a common agreement and say, so we should follow common principles of international exhaustion worldwide. This is the demand which is being made. So thank you everyone for your listening. And now we are open for questions.
Thank you very much. First of all, thank you for your preparation of such a presentation, because before the forum was, how would say, before we decided that we will organize this forum this year, it was a very short notice, and we asked you to prepare such a research, such a presentation that was very short of time. Thank you very much. It's very interesting, and I would, I think, add some issues to how it was in Russia, the history of exhaustion of rights, because actually before 2002, we had international regime, because no statement in our legislation made it possible to international, made it clear that we had international regime. So starting from 2002, yes, there appeared our national regime, and that was perfectly done about Porsche case in 2009. Yes, that was some landmark case. So starting from 2009 to 2011, there were some cases when the administrative responsibility was no responsibility, administrative responsibility, but there was civil responsibility. So from 2011 to 2018, everything was stable, but starting from 2018, parallel import was still prohibited, but there were some cases where sometimes it was actually permitted. So instability appeared. Starting from 2020, our federal anti-monopoly service had some cases, some rulings stating that it was unfair competition to parallel import. And this year in March, we had this statement of our government, which said that, yes, now we have international regime.
Parallel imports.
Yes, but the special list of products should be actually settled by the government. And on 19th of April, there was such a list declared. Up to, as far as I know, this list
particularly, I can say that those companies which have end up their ties up with Russia. So regarding those companies, they have allowed parallel import of goods.
So the reason for this statement is quite, yes, understandable. This list, yes, has the list of products of companies who decided to stop their business in Russia. But I think that this list is not signed properly. For now, it's just declared, but it should have some proof by legislators. I would also like to say a couple of words about the United States of America, because when we have such a new practice in our country, of course, we look everywhere. We need to understand what's going on outside and how it works worldwide. So in the United States of America, actually, there is international regime of exhaustion of rights.
I think there is national exhaustion.
It's international, yes, but they have three issues. First of all, the quality of products which are imported to the United States of America should be the same. So anti-monopoly service, of course, checks. There were some interesting cases. I think it was about soap, when one producer had some fabrics in the United States of America and in the United Kingdom. And due to some preferences of people, the quality of soap was a bit different, maybe to preferences of people or buyers, or due to some difference in water qualities for soap to be, for example, more misty or whatever. So there were some cases when the customs said, okay, both products produced inside of the United States and outside of the United States, they are produced by the IP holder, because they are both factories owned by this IP holder, but the quality is not the same. So it's not allowed actually, because buyers in the United States of America who got this imported soap said the quality is bad, so we are not satisfied, something goes wrong. So the United States said the quality of the products imported should be the same as produced in the United States of America. So the quality should be the same. It's the first point. The second point is about the marking of the product, because United States of America have pretty fixed list of how the product should be marked. So imported product, so you can parallel import, but follow our regulations on marking, and that's just absolutely clear. And the third point is technical support. So when the products imported are some technical difficult products, we talk about techniques, so technical support should be organized in the United States on the proper level, and I think it's just the perfect combination of issues to allow parallel import and to protect the buyers inside the country who has this international regime. So I think that in this situation, customs and Federal Anti-Monopoly Service should have enough authorities and should have enough possibilities to check all these three issues. And in that situation, taking into account these 3 points, that's just perfect situation to protect the buyers inside the country. So that's just some notes for people who were listening. Please, if you have some questions, please feel free to ask them in chat. And maybe if you would like to ask questions by voice, I think that I can allow to switch on your sound. Please feel free, because the aim of our international events also to practice English, to talk. I see some of our partners in the list of participants, so please feel free. Also, I would like to add some translation of a term which is not widely used in Russia: implied license, подразумеваемая лицензия, because we talk a lot about parallel import, we talk a lot about exhaustion of rights, but we do not you really often use this term implied license. It was used in your presentation, so I need to make sure that people understand this term. Okay, so thank you very much. I have one more question about exhaustion of rights in India. We understand that it's international regime. Do you know about some law cases, or sorry, court cases, some maybe interesting disputes concerning such parallel import issues or exhaustion of rights? Because in Russia, we have this history of parallel import. The landmark of this history is actually some court cases. So are there any, if it's difficult to think right now, I think that we can share with our participants a bit later, but if you know any, that will be interesting.
Yes, ma'am. Actually, when I searched about the case laws, unfortunately in India, we do not have much precedents with respect to parallel imports and this doctrine of exhaustion. There are very few cases. Again, also it's not clear, like there is no proper interpretation with respect to the law that is provided. So when we talk about this doctrine of exhaustion, or we say patent parallel import, so there is a bit of the concept is not clear, because it says that the patent, it should be the importation of a patented product by a person, from any person who is duly authorized by law. So many a times, if the case is presented in a court, so many a times the dispute, like I can from the from the research that I have done, I can infer that the disputes which are presented to the court, they are more on the issue that which law will be followed. Like when you're talking about duly authorized by law, so which law you're talking about? Either it should be the importing country's law you're talking about, or the exporting country. So again, so mainly the disputes arises with respect to the interpretation of this duly authorized by law, right? Now duly authorized by law, so again, so the interpretation, so if you are talking about exporting, if we, let's say, if we following the law of importing country, that means, let's say for instance, we are taking the importing country India. So again, so it is considered as a flawless interpretation, since it says that now the producer is in another country and you are obliging the producer or seller of that country to follow the Indian law. So that interpretation seems very absurd. So now in that case, from all the major judgments that I have seen, or there was this circular which was issued in the year 2012. So in that circular was basically issued by Customs Authority, Indian Customs Authority, whereby they specified that the law that we are talking about, basically it should be the law of the exporting country. And not the importing country that should be followed. So the exporting country's law should be followed in this particular sort of interpretation.
So we will also see whether that exporting country follows international exhaustion or national exhaustion or regional exhaustion. And after all these rules and compliance, then we will say whether that person has patented in India or that other country,
or whether there has been an infringement or not. So it shall it's a very tricky issue, since all the countries' law, it is very much dependent on the other countries' laws.
You will never know that a person who is getting his product patented. So if he's getting product patented in India, or he's getting it patented in some other countries or not. So a lot of these are coming nowadays, and now our courts, particularly the Delhi High Court, they have gone a little bit into the jurisprudence of this law of patent, and now they have become active. So coming 2 to 3 years, there will be a lot of precedences which will be dealing with all these cases.
Okay, and also I would like to make sure that we are talking about patents, and we can also say the same about trademarks. Yes,
right, absolutely. So but yes, and also in trademark, there is, unlike patent where we have some sort of ambiguity with respect to the application of law, similar is not the situation with trademark, since in trademark it is explicitly mentioned that there is international, we allow international exhaustion, and also the law which will be applicable. So in that case, the provisions with respect to trademarks are clear, but there is some sort of ambiguity in patent.
Like in copyright, we follow national, so like different jurisprudence. So exhaustion of IPR doesn't mean we are following international exhaustion in all the three: trademark, copyright, and patent. There may be different jurisprudence for copyright. Likewise, this is happening in other countries also. They're not clear which they will follow in trademark or copyright.
Okay, thank you very much. We would also congratulate you with the International IP Day, which was celebrated yesterday. But I think that while our forum is on, we're still celebrating for all this period of time. So once again, our congratulations to you and your colleagues. I think some people are still joining our event, but once again, the video will be then downloaded. Actually, in Russia, after the forum is over, we have such bunch of May holidays, and we will have some small period when we don't have a lot of working days. So after the 10th of May, we will make all the videos available to all our participants. This year, the participants got the link only while being registered as participants. So we have all participants who are really interested. It's not, the link was not shared in public domain, and people who are here today with us are really people practicing IP or interested in IP law. So we again welcome everyone to the rest of our events today. At 11 a.m. we will have a presentation conducted by Elena Fedoruk. The topic of her presentation is intellectual property and artificial intelligence. She's writing her postdoctorate paper and will report on that topic. On 12:30 Moscow time, we will have specialist on trees, Alexander Privin. He will tell us about patenting of innovations using trees theory. Trees, it's not translated into English, but I will try to. Theory of solving innovation and invention tasks. Actually, it's a word known as trees without translation. I think everyone who is interested can Google trees. As again, still accepting participants. So he will tell us about how to improve some technical solutions in order to then patent them, and in order just to develop the technical issues of something which is already known. And the next is a workshop which is called Drafting a License Agreement. It will start at 3 p.m. Moscow time. And I would like to invite everyone, because my teacher of legal English will tell us about some provisions of a contract, and I would add some points about license agreement as a variant of a contract. So for people who are interested in legal English, that's extremely important when you draft some kind of contracts and agreements, and this time we will talk about license agreement. So it will be kind of interactive. I also welcome everyone. So I think we can
greetings
sure.
to Natalia.
Once again, sorry.
Give our greetings to Natalia.
Sure. Yes, Natalia, I think she's online also with us today. We will forward, yes, all the greetings to her, and she will write to you also. And we will provide a certificates of for speakers, for all the speakers, and also for participants who would like to get such a certificate. Please tell your students if they would like to, just write an email to us, and we will provide such things. Okay, so thank you once again.
Thank you.
Thank you so much, ma'am. It was really an honor to present in front of you.
That was very interesting.
Like to come in Moscow.
Yes, ma'am. And we would like to interact more on these relevant and recent issues.
Okay,
in the coming.
Thank you very much. Looking forward for our next events and cooperation. So IP is something which is very, very, very important for all of us. Thank you very much. So we are finishing for now.